Welcome back. In this lecture, we take up really one of my favorite topics in the law, which is negligence. Negligence is the violation of a duty of care that causes harm to another. And I mentioned the regulatory effect of tort law previously. Tort law provides much regulation in our society. And oftentimes that regulation is a result of the law of negligence. The law of negligence plays this huge role in our lives, whether we know it or not. And because of its importance, this is why the law of negligence requires special scrutiny from future business managers like yourself. So in this lecture, we're going to look at negligence law and the elements of a negligence claim. Negligence is the failure to exercise reasonable care to avoid injury to others. A party is negligent when they fail to act as a reasonable person would do in the same or similar circumstances. So negligence law protects individuals against the harmful acts of other members of society. If someone runs a red light and strikes your car, they have failed to do what a reasonable person would have done, which is to stop at the red light. Now, negligence does not require intent. Negligence is accidental in nature. You need not have intended to run the red light. You simply missed it, or perhaps your attention was diverted, or the sun was in your eyes. All excuses, all good excuses. Nevertheless, you have not done what a reasonable person would have done in that situation. Now, negligence could also include liability for failing to do what a reasonable person would have done in that situation. And we'll talk more about this. Now, negligence is composed of 5 elements, and these 5 elements are derived from common law. You should know these 5 elements for your exam. There will be some aspect of the exam that tests you on each of these elements. And what elements mean when we talk about elements is that each of these must be present in order to succeed on a negligence claim. So first of all, the first element is a duty of care. The defendant had a duty of care. Now, we're going to talk about all of these in more detail, but let me go ahead and give you the 5 elements. So, duty. The second element is the defendant breached their duty of care. They failed to do that which they were required to do. So duty and breach are the first 2 elements of negligence. Causation. Now, there are 2 aspects of causation for the existence of a tort, and we'll take these up in turn. But the first type of causation is called cause in fact. And cause in fact usually refers to what we know as but for causation. But for the defendant's acts, the plaintiff would not have been injured. So it's a cause in fact. Now, more complicated causation comes up with the idea that the defendant's conduct must have been the proximate cause of the plaintiff's injuries. Meaning there must be a relationship between the breach of the duty of care and the type of harm suffered by the plaintiff. It is not enough that the defendant owed a duty of care and breached it. That breach must have been the proximate cause of the plaintiff's injuries. And finally, damages. The plaintiff suffered actual damages. You must show harm in order to recover on a negligence claim. Let's start with duty of care. A duty of care is simply a legal obligation to act reasonably. And again, this obligation exists regardless of any contract we made or promises that we made or haven't made. A duty of care exists to exercise reasonable care for the physical safety of others or for property damage. So a plaintiff is under a duty to everyone to exercise reasonable care for physical safety or property of others. Now, a duty of care usually arises in one of three different situations, and it's this first one that we are most concerned with. A duty of care exists if the victim was among those who would foreseeably be at risk of harm from the actor's conduct. So a duty of care exists if the act of the defendant could reasonably harm the victim, a person like the victim. So a duty of care exists if the victim was among those that were supposed to be protected by the duty. So if you had a situation in which a person had a swimming pool in their backyard and it was unfenced, even in the absence of a statute or an ordinance requiring a fence, the fact is, if you are maintaining this swimming pool in your backyard, it is foreseeable that a child will jump into the swimming pool and perhaps drown. So a duty of care exists because the group of people that may be injured by your act fell within that certain scope, that it was reasonably foreseeable that someone would fall into that pool because you did not have a fence up. Now, duty of care also exists if there is a special relationship between the defendant and the plaintiff. For instance, one of the special relationships we hear about all the time has to do with a business as operating as a landlord and its invitees, its customers. The business may owe a duty to its customers, its business invitees, because those customers could be injured by acts of the business. And finally, a duty of care exists if a regulation or duty provides for one. Returning to our example of the swimming pool in the backyard, if there was a county ordinance that required a 5-foot fence around the swimming pool, then the owner of the swimming pool has a duty of care to anyone based on the fact that there's a statute saying you have to have a 5-foot fence. So yes, violation of the 5-foot fence rule would be a crime, but it would also be a tort because there was a duty of care owed to anyone that was going to be protected by that rule. Now, generally, there's no duty to rescue. There's not a duty to act or to rescue someone unless you assume the duty. So if you are an EMT on your off hours and you're driving and you spot an accident, there is no duty that says you have to stop and rescue one of the people injured in the accident. However, if you do stop and you start to apply CPR, then you now have assumed a duty of care to that person. That now assumption of a duty may lead to a claim of negligence. Let's talk about this case in your book, James versus Meow Media. This is a tragic case. It involves a school shooting by a 14-year-old at his high school that resulted in the deaths of 3 of his classmates. Now, the parents and administrators of the victims' estates filed a negligence lawsuit against several companies that produced or maintained certain video games, certain movie, and certain internet websites. Now, the argument was that these video games contributed to the shooter's lethal state of mind, and therefore these activities, playing the video games, desensitized the person to violence and caused a lethal state of mind that led to the shooting spree. Now, the district court dismissed the case on the basis of no duty, and the appellate court upheld this ruling. The court used a negligence analysis to find that the harm to the injured party resulting from the defendant's negligence was not foreseeable, meaning those victims of the violence, it was not foreseeable that a person who played that video game would go out and kill fellow classmates. So, because it's not foreseeable, and the reason it's not foreseeable is that millions of people interact with movies and video games and websites and do not go on shooting sprees. There was not a special relationship between the parties. There was no landowner, employer, those type of situations. So, no duty owed in that case. Now, the second element is breach. If the defendant failed to act as a reasonable person would act, then the defendant breached the duty of care. Now, how do we measure breach? How do we know what a reasonable person would do? Well, we use what's called the reasonable person standard. And the reasonable person standard establishes the standard of care. So what the law says is that a party who owes a duty of care must act as a reasonably prudent person would do under similar circumstances. So a plaintiff in a negligence case has to prove that the defendant did not act as a reasonable person would act in that situation. The reasonable standard, the reasonable person standard. Now, there are other aspects of breach, one of which is called negligence per se. Negligence per se results from a violation of a safety statute. So going back to our previous example of the swimming pool and an ordinance requiring a 5-foot fence, if a person did not have the fence, that's enough to establish breach of the duty of care. You violated a statute that was aimed at safety, and therefore you have breached the statute. We don't have to examine whether a reasonable person would have had a 5-foot fence or not, because the statute has already done that work for us. Because of the existence of the statute, we know that a reasonable person would have a 5-foot fence. Now, the second aspect of breach that we will discuss is what's called res ipsa loquitur. Res ipsa is a Latin phrase that means the thing speaks for itself. There, we can infer negligence from the circumstances. This type of accident would not happen unless there had been some negligence. So if you are a private airplane pilot and you go to have your plane filled with aviation fuel and you drop it off at the hangar, they come back and tell you your plane is full, you take off and flying the plane, a half hour later you run out of fuel and crash. Now, why did you crash? There wasn't enough fuel in the tank. The defendant, the company, the refilling company, did not actually refill it. Well, we don't need evidence of breach of a duty of care because this thing would not have happened but for the breach of the duty. So res ipsa, the thing speaks for itself. So we have a duty of care and we have breach, and now we turn to the subject of causation. A defendant is not liable just because of the breach of a duty of care. The breach of the duty must have caused the problem. Now, causation, as I mentioned, is composed of two elements. The first is actual cause, but for cause, and we call that cause in fact. But for the defendant's act, the harm would not have occurred, but for causation. But you must also prove legal cause, known as proximate cause, meaning that the breach of the duty that caused the injury must have been the legal reason for the damages. So let's look at cause and fact first. Cause and fact refers to but for causation, and it's an act or an omission without which the plaintiff's injury would not have occurred. And in fact, two parties can both be the cause and fact of an injury. If you have a house and someone on the left side of you starts a fire, and then simultaneously the neighbor on the right starts a fire, and then somehow those fires become out of control and destroy your house, technically you could argue that it's impossible to prove but for causation. The neighbor on your left didn't do it because the fire on the right side would have consumed it, or vice versa. Well, the law takes this legal fiction that two parties can be the cause and fact of an injury. And in fact, causation can be established if the act or omission is a substantial factor. Now, proximate cause requires that the negligent act be closely related to the injury. And that's why we call it proximate cause. There must be this aspect of cause, which is an element of closeness, an element of proximity. And so when we look at proximate cause, we need to look to see, was the injury the result of an event close to it? Are the cause and the harm that was suffered closely enough related to find liability? Now, the most important factor in determining proximate cause is foreseeable. Was it foreseeable that the breach of a duty of care could have caused this particular injury? And so oftentimes we don't even refer to it as proximate cause, we simply refer to it as foreseeability. Was it foreseeable? And if the harm is not foreseeable, there is no proximate cause. Now, the case that is cited in every law school in the country for proximate cause, really one of the most famous cases in legal history, is known as Palsgraf versus Long Island Railroad Company. Now, this is a very famous case about proximate cause, and the facts are interesting. In this case, Ms. Palsgraf, a woman, bought a railway ticket for a train, and she was waiting on the platform for her train. Now, a different train arrived on a separate platform, which was a good distance away, about 100 yards away from her where she was standing. Now, that train began to slowly depart from the station. Now, one person was running to catch up with the train, a passenger on the other train, not the train that Miss Palsgraf was waiting for, but a passenger on another train. And two of the conductors reached out and pulled the running man into the train car. Now, here's where it gets a little bit odd, that the man who was running for the train was carrying a package, and that package turned out to be fireworks. And when he was pulled onto the train, the fireworks fell out of his hand, they fell to the platform and exploded. And it caused a blast. And the blast shook the station with sufficient force that these large iron scales, under which Miss Palsgraf was standing, fell on her. resulting in a severe injury. And so Miss Palsgraf sued the railroad for the negligent conduct of its conductors. Now, the railroad had a rule that specifically prohibited pulling a person onto the moving car. And so there was a duty of care owed because there was a rule that you should not do what the conductors did. And the conductors undisputably pulled the person onto the vehicle, to the moving train car. So breach of the duty of care is there. Cause and fact is there, yes, but for pulling the man onto the train car, the fireworks would not have fallen out of his hands and would not have exploded, which would not have caused the blast that caused the scales to fall on poor Miss Palsgraf's head. So we have breach, we have duty of care, we have breach, we have cause and fact, but now the question is, was there a close enough relationship between pulling that passenger onto a separate train and the scales falling and striking Miss Palsgraf in the head? And the court found that it was not foreseeable that this rule, this pulling a passenger on a plane, might cause an explosion to occur, which would cause a large heavy object to fall on the head of a future passenger standing on a platform 100 yards away. So this case is very famous for establishing there must be a close causal link between the breach of the duty of care and the actual harm that was suffered. Finally, damages. A plaintiff must suffer actual damages in order to recover. It can't simply be what I used to call a hurt feelings case. It must be more than hurt feelings. There must be some sort of physical harm and a resulting loss in order for the plaintiff to recover. Now, there are defenses to negligence, and the defense is a means of reducing liability. Now, the first defense is called contributory negligence. Now, contributory negligence used to be the law everywhere, but now contributory negligence is only utilized in 4 states in the Union. And what contributory negligence states is that if the plaintiff's negligence, if the plaintiff's own negligence led to a problem, even if that negligence was 1% of the injuries that were suffered, then they should not be able to recover anything. It's a very harsh rule that existed, this idea of contributory negligence, this idea that if the plaintiff did anything wrong, the plaintiff could not recover for the harm that they suffered. Contributory negligence. You did something that helped to cause the harm, and therefore you contributed to the accident. Now, contributory negligence, as I said, was a very harsh doctrine, and so the law then responded in a number of different ways, creating other different rules, but eventually, beginning really back in the 1940s and continuing through the 1980s, every state, except for the 4 that we mentioned previously, adopted what's called comparative negligence. And what comparative negligence means is that you can sue the party, the negligent party, even if your own acts contributed to the harm that was suffered. However, your damages are going to be reduced by the percentage at fault. So if you are involved in a car wreck and it appears that you may have been partially at fault, but the most fault belonged to the other driver, then we will ask a jury to apportion damages accordingly. And so that jury, when they go out to deliberate, they will first of all find, is the defendant negligent? And if so, assign percentages of fault to both the plaintiff and the defendant. And if the plaintiff was 25% at fault and the defendant was 75% at fault, then the jury verdict is going to be reduced by 25%. Comparative negligence. Now, comparative negligence, as I said, is the law in most states in the country. Now, it is utilized in different ways. Some states allow for what's called a pure comparative negligence standard, which is to say, even if you are 99% at fault for the accident, you still have a right to recover the 1% that the defendant was at fault. Now, other states approach that differently, and they follow either what's called the 50% rule or the 51% rule. And what that says is that if the jury determines that the plaintiff in a 50% state, if the plaintiff is 50% at fault, they recover nothing. In a 51% state, if the plaintiff is at 51 or greater, then the plaintiff recovers nothing. So it's sort of a modified contributory negligence rule. It's a modified comparative negligence rule. It puts limitations on the state in terms of recovery. Now, the final doctrine is a doctrine that I don't really like to focus on too much, although it's utilized all the time, and this is the idea of assumption of the risk. That if you assumed the risk, then you cannot recover. And we used to see assumption of risk claims oftentimes in people who go to a baseball stadium to watch a baseball game, and they are struck in the head by a foul ball coming off the batter's bat. When they sued for negligence, almost invariably the defense was, you assumed the risk. You went to a baseball game, you knew that foul balls could happen, and you may be struck by the ball. So that's assumption of the risk. Now, assumption of the risk is, again, a harsh remedy. And so in most states, assumption of the risk has been subsumed into comparative negligence. That it's no longer contributory negligence in which you are barred from any recovery, but instead it is focused on comparative negligence. So if you go to the baseball stadium, you know that there are areas in which a net is up to protect people from foul balls. And if you are concerned about being struck by a foul ball, you have the ability to sit behind that net. If you don't sit behind the net, then your percentage of recovery should be lessened by the percentage of fault. There's a lot more we could say about that, but I just want to give you an overview of how this works. Now, the final topic we have to discuss is product liability, and that is closely related to negligence. Product liability refers to the liability of any seller of a product that, because of a defect with the product, causes harm to the consumer. So in a product's liability case, the injured party can pursue recovery under one of three theories. The first of these being negligence. First of all, negligence was not typically used as a remedy because the law protected only the actual purchaser of the product. So in a case involving an automobile manufacturer, the automobile manufacturer sold a car to the car dealer. The car dealer then sold that car to a customer. The car had a defect that caused injury to the car customer. Now, under traditional analysis, the auto manufacturer only owed a duty to its own customer. It did not owe a duty to the world. But in this particular case, it was a very famous case called McPherson versus Buick. The court held that a party that negligently manufactures a product is liable for any injuries to persons who are where the injuries are proximately caused by the negligence. So manufacturers have a duty of care that extends beyond their customers to essentially any person that may be negligently harmed. So things like proper design or manufacturing or testing, inspection, and shipping. The manufacturer has responsibility to anyone who may be harmed by a defect in that area. Now, the second theory of recovery has to do with warranty. When the seller makes a representation of fact about a product, this is known as an express warranty. And even if the seller has not made a specific representation about the product, the buyer may still be protected by sales law. Sales law provides for an implied warranty. And the third theory of recovery is strict liability, that if the buyer, the injured party, let's say, can show that the product was in a defective condition when it left the manufacturer's premises, and that the defect rendered the product unreasonably dangerous, then we could apply the notion of strict liability. Now let's look at the elements of a product liability claim. First of all, you have to show that the product was defective. The product was defective. The defect existed when it left the defendant's control, and the defect caused the plaintiff's injury. Now, what is a defect? Well, there are different kinds of defects, starting with design defects. The design of the product was bad. It was defective. And so the manufacturer, who may have purchased the product design from someone else, we focus on the design defects causing the harm. Now, manufacturing defects are separately, that the design could have been perfectly good, but the manufacturing of the design could have caused a problem that caused an injury to a third party. And finally, we have marketing defects. And this generally is known as a failure to warn or failure to adequately warn. So when you get onto an ATV, if any of you have been on an ATV in recent years, you can look around and you will see multiple warning labels affixed to the ATV. Very difficult to remove these labels. The labels are plastered on there about potential uses of the product. Warning. Now, the reason why there are so many warnings on an ATV is that someone has been injured, and their argument is the ATV was defective not because of its design or because of its manufacturer, but because the seller of the product failed to warn of the harm that could be suffered. And so on your ATV, there will be a warning not to be operated by anyone under the age of 16. Why is it there? Because someone under the age of 16 has been injured and they have sued the manufacturer or the seller for failing to warn. So marketing defects can lead to a product liability claim as well. Now, there are defenses to a product liability claim, starting with misuse of the product. That if you are a manufacturer of, say, a weed eater type lawn appliance that is used to clean out weeds from around tree trunks and such. Well, if you hold that weed eater over your head to trim a tree and you wind up injuring yourself, then the manufacturer could claim that you misused that product. You used that product in a way that it was never intended to be used. Assumption of the risk, again, just operates exactly the same as we've said before, and comparative negligence does as well. So these are defenses to product liability that are the same as the defenses to a negligence claim. So in conclusion, what did we learn today? We learned that negligence is the failure to act reasonably, a failure that causes harm to another. Now, there are 5 elements of negligence, and again, make sure you know these 5 elements and know what each one is. Duty, breach, cause and fact, proximate cause, and damages. And a business may be liable for defective products regardless of their own faults. That's it for this one. Thanks for listening. If you have any questions, please let me know.